Judge Wallace says he should be clicking in just a minute. So, I see. I think we're getting some action. There's Judge Wallace.
Good morning.
All right, good morning, counsel. We're here on the case of Michael Johns versus State. Counsel, you all have 20 minutes per side to argue the case. This is being recorded on YouTube. I think with that, we'll go ahead and get started. Counsel?
Thank you, Your Honor. Good morning. May it please the court, counsel. Robert Pierce on behalf of Michael Johns. We request 5 minutes of rebuttal time. Well, we're here this morning on Mr. Johns, following the denial of Mr. Johns' motion for post-conviction relief, in which he argued that his counsel was ineffective for failing to object to the trial court's consideration of unsubstantiated matters in sentencing. Now, the issue is whether he was ineffective, but it's actually a little bit more simple than that, given the state's position in their reply. The state, just as the trial court below, does not contest that the comments from the trial court were unsubstantiated. Those comments specifically, reading from this court's reversal the last time this case was before it, regarded the trial court's comments about my client's, quote, psychopathy, end quote, and that he might, quote, might be a budding psychopath, end quote. The trial court below didn't argue that these were substantiated by the record. The state doesn't argue that these comments were substantiated by the record. Instead, both are taking the position that these simply weren't related to sentencing. The court's comments were unrelated, apropos of nothing. They just happened to be said immediately before pronouncing sentence. I think a review of the transcript makes it abundantly clear, beyond any doubt, that this just isn't the case. The court begins its commentary. This is the beginning of its sentencing colloquy. Thank you very much, Mr. Michael Johns. One of the factors the court has to take into account.
Counsel, I think all of us have reviewed the specific comments that the trial court judge made. My first question for you is a legal one. Other than our opinion that reversed for an evidentiary hearing, were you able to locate any other case law that suggested that simply an unsubstantiated allegation at sentencing is appropriate to cause fundamental error, other than what it seems like the body of case law suggests, which is that it's an unsubstantiated allegation of misconduct? And then my follow-up question to that would be, is psychopathy misconduct?
Thank you, Your Honor. So regarding the first question of whether or not whether it has to be misconduct or it can be any matter, the due process part of this error is that it's unsubstantiated to begin with, and that it's influencing the court's sentencing. So when the court is bringing in outside matters that haven't been vetted through this sentencing proceeding, it's necessarily violating his due process rights because it's something that has not been put through those due process rigors, right? The follow-up question was whether or not, I apologize.
Is psychopathy misconduct, or are we talking about an expansion of due process rights from the existing case law?
Right. So I would say that psychopathy generally, just referring to someone as a psychopath, is both pejorative and indicative of misconduct. But the comments here we know are related to misconduct. So if we go back to those comments, in between the two that were quoted in the reply brief, the court goes on to say, it does appear that you might be one of those sadly afflicted individuals that is intractably attracted to underage girls. And there is a whole body of knowledge or a study about that from psychologists and mental health professionals that indicate that while people are born and they go along through their young lives and hopefully they develop age-appropriate feelings toward the opposite sex or the same sex, but the bottom line is that as you age, 10-year-old boy is kind of interested in a 10-year-old girl, and a 17-year-old boy is really interested in a 17-year-old girl, et cetera, et cetera. And you might be one of those people that's kind of hardwired to say, you know, at 15, I'm going to stop, click, the switch goes off, and I'm only going to be interested in 14 and 15-year-old girls for the rest of my life. That's what it sounds like is developing for you, Mr. Johns, and that is still sanctioned by the law. So the reason that this is more than a pejorative issue is that it has to relate to their potential future criminality. This is in the issue, I believe, in Goldstein v. State, which was another case out of the second DCA, where the court was, in essence, punishing the defendant for out of his fear of the commission of future crimes. So while just referring to the defendant with a pejorative or insulting tone or term may not in itself always be an unsubstantiated allegation, here that allegation is tied specifically to future misconduct and present misconduct. It's related to the allegation at issue in this hearing, which was that he was contacting minors. Now, the context here is important for the purposes of prejudice as well. My client had been placed on probation. He was serving 3 concurrent 5-year terms of probation after a relationship of his with an underage girl. He was 19, I believe 18 at the time, 19 at the time of sentencing. One of the conditions of his probation was that he could not contact minors, but he had 2 other siblings that had been adopted by another foster family. He moved the court pro se to speak with his younger brothers. The court eventually granted that motion, but before it did, he texted them. That's the violation in this case. So when the court is commenting on his psychopathy, when the court is making these comments about how he's intractably attracted to underage girls, and specifically in the context of this contact with his brothers, and the problem with all of this is that there's no basis for any of these comments of labeling him a psychopath, of saying he's intractably attracted to underage girls, of saying he's going to go the rest of his life like this, that he's a danger of this conduct in the future. And because these allegations weren't put through due process, because they're apropos of nothing, coming up in the middle of the sentencing colloquy immediately before imposing the maximum sentence available, 15 years in prison for this 19-year-old kid. Because of that, the prejudice is clear. And because the state isn't contesting that these are unsubstantiated, it really does come down to your question of whether or not this term of these comments are unsubstantiated matters that are affecting the sentence. It's clear that they are affecting the sentence. It's clear at least that there's the reasonable probability, which is the legal standard, of that they're affecting the sentence, because they're the sole justification, the only justification given from this court for the most serious sanction available to it, taking this 5 concurrent probationary sentence, 5-year concurrent years of probation, and turning it into 15 years incarceration, solely based off of the judge's allegation that my client's a psychopath when there was no evidence of that and nothing to support it.
Counsel, is there anything in the record that would suggest that the court did a Strickland analysis? In other words, determining whether the failure to object to those comments was deficient performance or whether it prejudiced the defendant?
Not a complete one, I think, is the best answer to that. The court is, as I was saying, hanging their hat on the fact that there was no reason to object, that the comments were totally appropriate. There was nothing that defense counsel could have objected to. This isn't a trial strategy argument in the view of the state or the trial court. This is instead, there was nothing to object to. And so the court stops at the deficient performance analysis and doesn't really get to prejudice because it considers the fact that he didn't object to be totally in bounds. There's no reason not to object.
Let me ask you to hold on just a minute. I noticed our clock just went back to 20. I don't know where it was when it just went back to 20. I don't know if our marshal is listening or not.
Your Honor, it had a power failure and it reset for a second. So I believe it was about 14 minutes when it went out.
Okay, thank you. So you've got about 14 minutes left.
Okay. So I think if I could narrow this down, since we don't have any dispute over whether or not the
Marshal,
yes.
to start the clock again, please.
Sure.
Okay, there we go. All right. You still got 14 minutes. Sorry to interrupt you.
No problem at all, Your Honor. And I'll try to be brief. First of all, since we don't have any dispute over whether or not these comments are unsubstantiated, it really does come down to whether or not these comments, these allegations against my client regarding his behavior were substantiated or were considered in determining the sentence. And as I was saying before, the comments themselves are expressly sentencing considerations. he refers to them as sentencing considerations.
Counsel, let me ask you, are you familiar with our case called Shelco versus State involving the same judge?
I'm aware of the name, but not of the substance of it off the top of my head, Your Honor.
Okay, then I won't ask you a question about it. Okay, go ahead.
Well, I'm happy to attempt.
Well, in Shelco versus State, the judge the defendant was charged with possession of methamphetamine, and at sentencing, when the defendant received the maximum sentence, the judge made comments about the cartel quality of the methamphetamine and certain similar comments. And our court said that there was no testimony or evidence to suggest that Shelco was involved in a drug cartel or acquired the meth from a distributor for a cartel. And we said that when the record reflects that the judge may have relied on impermissible considerations in imposing sentence, the state bears the burden to show from the record as a whole that the judge did not rely on such considerations. So I guess I have a two-part question. Number one, how does that impact this case? And number two, how does that address Judge Traver's case that other than our reversal in this case, there haven't been any similar rulings?
Well, I think Your Honor hit the nail on the head with Shelco. And the case sprung to mind, or the facts of those quickly came back to me as you started reading them. Just like in this case, in Shelco, we don't have an allegation of misconduct. We have just a comment about the quality of this, in that case, the methamphetamine. And it's not necessarily, it doesn't fit squarely into the unsubstantiated allegation of misconduct, like bringing up a battery, say, in the middle of a sentencing hearing that wasn't testified to at sentencing. But it is related to the thing that is impacting the court's determination of sentence, because the court is expressly saying this is what is impacting my sentence, and it is unambiguously something that is unsupported by the record. And so, for the same reason as in Shelco, I think that warranted an objection. Now, this case is only distinguished from Shelco in one material respect, which is that in Shelco, as I recall, it wasn't a motion for post-conviction relief. Instead, it was just a direct appeal. And so the question is slightly different, although that distinction isn't really material for the issue here, specifically because the court is hanging its hat on the fact that there was no reason to object since this was fine. Whereas, or while if it wasn't fine in the first place, as it wasn't in Shelco, then the court is wrong in that analysis, that it was actually deficient performance for failing to object to the court's express consideration of unsubstantiated matters. And therefore, the deficient performance prong of Strickland is met. The prejudice prong is met even more, or it is kind of an afterthought at this point, because we know, given the maximum sentence that was imposed, just as in Shelco and as in Johnson, which was the case that relied on in the initial brief and reply brief, that the imposition of this maximum sentence after the express consideration of an improper factor establishes that prejudice prong of Strickland.
If a trial judge considers an unsubstantiated matter and bases sentencing on it, is it always fundamental error?
Yes, Your Honor, it is.
So if the trial judge says, for example, based on my experience, I'm sentencing you to the max, that's not something that you could substantiate or empirically test, is it?
If he's saying, based on my experience,
sure,
without
as a 20-year trial judge, based on my experience, I'm giving you the maximum. That's certainly not something you would concede that we could perform an empirical study on, correct? And it's not based on the evidence. So is that fundamental error?
Well, I before answering that, I have to inquire as to the hypothetical. So is he saying, based on my experience, and then simply going into sentencing, or is he saying, based on my experience, you're a psychopath?
Nope, just based on my experience, I'm sentencing you to the maximum.
There's very little anyone can do to challenge a court just imposing sentence without giving a reason for it. The problem, the violation, the error that comes up in these cases is where the court's comments create the appearance that it's relying on an improper factor. So the difference between your hypothetical and this case would be, in your hypothetical, there is no statement that is creating the appearance of reliance of a reliance on an improper factor. Whereas here, the court's expressly saying the reason for my sentence, one of the factors I have to take into account in sentencing is your psychopathy.
I guess the reason I
would be the
ask is
distinction.
because it relates to the way that this opinion would read if we agree with you in reverse. And if the statement is all trial court sentencing must be substantiated by evidence in the record, do you foresee that that could have some unintended consequences?
No, Your Honor, I don't. I understand the concern, though, and I think I should clarify that a court exercising its discretion, saying that, in my opinion, based on your prior record, this is the appropriate sentence, there's nothing wrong with that. There's no error there. There's no unsubstantiated matter there. It's the internal process of the court exercising its discretion. And judges, of course, are entrusted to use their personal experience, their time on the bench, the things that they've seen before them, involving prior record, as to determine the appropriate sanction. They should be judging cases equally, after all, imposing the sentence as fairly as possible across every case that comes in front of them. They can't just forget one and move on to the other and decide it totally in a vacuum. That's very different, though, than incorporating into the sentence, into the things determining the sentence, bringing in things that weren't put through the due process rigors of a sentencing hearing. And so requiring a court to rely only on those things that are substantiated by the record isn't a hindrance on the trial court. It's, in fact, what trial courts have been doing, or ought to have been doing, for decades. The court has the Florida statutes, which set out exactly what it can consider. It has a pre-sentence investigation, which includes things the court can consider as well. That they're not hemmed off from considering any number of factors that are before them. But what they can't do is consider factors that are unsubstantiated by the record at all. They cannot begin their sentencing colloquy and say, I'm considering these things that were not testified to, were not subject to cross-examination, there was no evidence of. I'm just bringing them in and then using that to augment what the sentence would be, or having those factors augment.
What if the trial judge says something to the effect of, so I've been in this division for a couple of years and you're accused of theft at a Walmart. This is, and I've noticed that there is an increasing number of thefts at this particular Walmart. So I am going to sentence you more harshly because I noticed that this is a problem in the community. Certainly we can agree that that's not independently something that you could substantiate, correct?
Whether, or you mean the fact that there had been prior thefts at that particular Walmart?
Well, it's certainly probably possible to check whether there was, but I mean, it's not part of the record, I guess is what I'm getting at.
So there would be two problems with that. The first, and respectfully, I'd have to disagree. The first is that you could very well bring in evidence of that at the hearing. There's no reason not to. And I think the same problem there, if the court did go out of its way to say, because of these other thefts at this particular Walmart, I'm going to sentence you more harshly, that would be one problem with the sentence. The other would be that it would at least come close to invoking an improper generalized sentencing policy, which is a separate improper sentencing consideration that's not at issue here.
Counsel, let me ask you a hypothetical that doesn't involve misconduct. Let's say, for example, that the judge says, you know, Mr. Defendant, I noticed that you're very tall, and I just don't like tall people. And as a result of that, I'm going to give you a more harsh sentence. I'm going to sentence you to the maximum. I mean, certainly being tall isn't any misconduct. There's nothing involved in that other than being tall. And it's not a suspect class. It's not like race or gender, or religion. Right. Defendant says, the judge says, I just don't like tall people. Could the judge max him out and we couldn't review that?
Well, I'm trying to consider what the particular error there would be. It certainly doesn't smell right. While it wouldn't.
Well, doesn't that come down to exactly what we said in the first iteration of this case? The judge can't rely on improper considerations. That's not evidence of misconduct. Being tall isn't misconduct. But would that be an improper consideration for the judge to say, look, I just don't like tall people. I'm short. I don't like tall people.
No, Your Honor, it wouldn't be a proper consideration. And I don't think we...
Would that be reviewable?
Yes, it would actually. Although under a different rubric than is at issue here. But to answer your question, yes, it would. Specifically, while in almost every case, the judge's imposition of a sentence that's within the sentencing guidelines is not reviewable, it is subject to an abuse of discretion standard of review. Now, typically, appellate courts are very hands-off with that sort of thing because the standard is whether it was arbitrary, fanciful, or reasonable. But I think if a court is expressly sentencing someone because they're tall, that would fit the definition of arbitrary, fanciful, or unreasonable.
All right, counsel, I think you've got about 2.5 minutes left.
I'll reserve. Thank you, Your Honor.
We'll see what we can do there. Okay.
Thank you, Your Honor.
All right, thank you. Counsel for the state?
Good morning. May it please the court. My name is Richard Palace. I represent the state. And it's the state's opinion that the lower court properly denied this ineffective assistance of counsel claim. While...
Do you concede that there's no evidence in the record to suggest or substantiate the statement that there's this, psychopathy or you're a budding psychopath?
Well, Your Honor, we agree that there's no expert testimony stating this person is a psychopath, this person suffers psychopathy as defined in the DSM. There is certain evidence of this person suffering from psychiatric issues. The fact that he was Baker acted, that there's a potential that he suffers from PTSD based on what his counselors at his sex offender counseling told his community control officer. But
it is substantially different than you're a psychopath, or I'm concerned that you're a budding psychopath. I mean, isn't there a big difference between he might have PTSD, which is, I think, what the statement was. The counselor said he might have PTSD, and transforming that into you're a budding psychopath, or I'm concerned that you're a budding psychopath.
Yes, Your Honor. The state does agree that there's a difference between this person might suffer from PTSD and then saying, I'm worried about your psychopathy. You may be a budding psychopath.
Do you think it's proper consideration?
Well, the state does not believe that this was a consideration. As it stated in its brief, the court didn't consider these unsubstantiated matters in giving its sentence. And
Counsel, my concern is there is specifically what Judge Howard said. There's no good cause as to why sentence and sanction should not be imposed. See, this is what I'm afraid of for you, Mr. Johns, is you might be a budding psychopath. From that sequence of sentences, it's very apparent, or it's very concerning to me, that that was specifically what Judge Howard relied upon, that unsubstantiated evidence, and followed by this ambiguous term, followed by maxing him out for a message. And basically what's been brought up in this OA is just a message to his younger brothers. So can you explain to me why we shouldn't be concerned that Judge Howard relied upon this unsubstantiated evidence as his reason for maxing the appellant out?
Well, Your Honor, the state can argue that while, yes, his sentencing statement was bookended by you may be a budding psychopath at the end, and then beginning with I'm worried about your psychopathy, those statements are sandwiched around him stating certain conduct of people being attracted to minors. And what's important here is this isn't just a case where someone received 15 years just for texting their brothers. He was accused of very heinous conduct in that this case stemmed from improper contact with a minor. He was charged with lewd lascivious molestation on a minor, lewd lascivious battery on a minor, and transmitting harmful materials with a minor.
But apparently the state felt comfortable in giving the guy probation. I mean, I didn't look back at the record to see if this was a negotiated plea, but if it's like the vast majority of them, I mean, although you can beat the drum now and talk about how serious the crime is, mean, the reality is that apparently, my guess is the state probably agreed to it. But when your point is the state didn't, the court didn't rely on this. And as a result, there was nothing for counsel to object to. But at the beginning of it, the judge says, even though the law does not require the court to give a reason for a sentence, I would have to join with Mrs. Raines, the probation officer, and be worried about your psychopathy. And then the judge goes on to talk about the whole body of knowledge from psychologists that indicate while people are born, they go through their lives. And, how is that any substantively different than the same judge expressing his opinion on the cartel quality meth? Well, I don't know how he determined that, but apparently not only is he a meth expert, but he is a psychology expert. I mean, a two-part question. Isn't it very clear that he relied on the psychopathy concerns? And if he did, is that a proper consideration?
Well, Your Honor, for the first part of your question, the state still believes that he didn't rely on these improper considerations. And what's important is what trial counsel stated in the evidentiary hearing. He recalled these statements, he read the transcript, and he has practiced in front of the trial judge for approximately since 2007, 2008. He stipulated as a criminal law expert. He's had criminal law practice for approximately 30 years. He heard these statements, and his observation of these statements was they were just generalized statements. They were observations along the lines of, well, it could be, that's a possibility, never stating.
Doesn't that misstate the Strickland analysis, though? I mean, why should we be preoccupied on what the trial counsel subjectively thought? Aren't we looking at whether an objectively reasonable trial counsel would have objected in that situation?
Well, Your Honor, on that particular point, Strickland specifically states that this scrutiny is highly deferential to trial counsel's performance. In fact, it's to eliminate distorting effects of hindsight. It is to reconstruct the circumstances from counsel's perspective at the time.
I understand that, but that doesn't really address the question. I mean, we can agree that it should be objective versus what you were just arguing, which is subjective, correct?
Well, Your Honor, in this case, it's understandably, it sounds like I'm stating subjective, but being objective in this particular situation, that he knows how this judge utters his sentences, where here he testified that it sounded like this judge already made up his mind that he was going to max this gentleman out because this gentleman was looking at far more strenuous sentencing. He was given a chance by the state. He proved that he did not deserve that chance by violating his conditions. He had improper contact with a minor. He then contacted minors against the rules, even though he was read these rules by his community control officer. He was given a chance. He didn't take the chance, and that's what he was punished for. Both this wrongful conduct that he did and the fact that if he's not going to follow rules as simple as this is what he'll receive. And he, trial counsel, of course, saw these facts, listened to these statements, and did not find that this rose to objectionable conduct.
Well, but again, Judge Traver's question is not what this attorney thought, but what would the objectively reasonable attorney do under the circumstances? Can you envision any tactical reason why an attorney would allow to go unobjected to a comment that basically the judge thinks the client, the defendant, is a budding psychopath? Is there any possible tactical reason for that?
Well, in terms of tactics, it is here, if he did object, what's important, Your Honor, is it is very possible the judge would have just stated, I'm not sentencing you for being a psychopath. I'm not considering your psychopathy in this. I'm just stated what I'm concerned about for you. Because he did state, this judge, trial counsel did state that this judge would say things like, you need to get on the straight and narrow. These are my...
You know, I looked at the transcript, and basically the trial counsel's argument or contention was, I've practiced in front of you, Judge, for a long time. I know you say a whole lot of things, but we know better than to rely on those things because we know you would just sentence him based upon legal factors. I mean, isn't that really what it comes down to?
That's approximately how, yes, Your Honor, that is how he categorized how this sentence was in this scenario. Of course, as you mentioned earlier, there was the Shellco case where he talked about the quality of meth. That is still different from him stating.
Shellco, which we said was fundamental error.
That's correct, Your Honor. And it is worth mentioning that in case number 5D14-2611, fundamental was argued in this case, or at least briefed on the direct appeal of this particular.
Wasn't mentioned until the reply brief, correct?
It was mentioned in the answer brief. You're correct, Your Honor, that it was not brought up in the initial brief. However, there was a motion also for written opinion stating that it was conflicting with the second DCA decision in, I believe, Goldstein.
Can you address Goldstein for me? There's a case that's referenced in Goldstein called Barnhill, and Mr. Pierce made the observation that one of the bases for sentencing that the trial judge expressed could be construed as something akin to Goldstein or Barnhill, which is that you might commit some future crime. I'm worried that you're going to be the sort of person that continues to use the language from Goldstein, touch children. Is that an improper sentencing consideration?
In a case such as Goldstein, where they're stating that future criminality is a problem, the courts have held, yes, Your Honor, that making a comment on future criminality would be a problem. But here you can argue that the trial court's not stating you're going to be touching young girls for the rest of your life. Again, we can go back to the conduct that he was originally charged with, and that he's being punished for touching the young girl and getting charged for that in the first place. And of course, violating then his community control for not following the conditions.
Anything else, counsel?
No, Your Honor, just that this court considers the high deference that we give to counsel. And if there are no other questions, I'll rely on my brief and I ask that you affirm.
Thank you so much. All right, Mr. Pierce, you've got about 2.5 minutes remaining. You're muted, though.
I'll go as quickly as I can, Your Honor.
Mr. Pierce, could you address that last point on Goldstein? The way that I understood counsel for the state, Mr. Pallas, to distinguish those cases was that the defendant in our case was on probation for that exact conduct. In other words, the child pornography cases are reversed, at least in part, perhaps, on the idea that somebody who's never touched a kid could in the future touch a kid. I think the distinction that opposing counsel was trying to make was that in those cases, a kid had actually been touched, and that's why he was on probation. Could you close that loop for me, please?
Certainly, Your Honor. I think the biggest difference between this and Goldstein, I think, is a factual one, or at least something I need to point out is the factual difference. The conduct at issue here wasn't touching another child. It wasn't contacting another child appropriately. It was texting his younger siblings, who were 15 and 17 respectively. It was texting them.
Offense.
The underlying offense was 3 counts of child abuse with no bodily harm.
But the allegations were having sex with his 15-year-old girlfriend, correct?
They were of a lewd nature. I don't know if it was actually sexual conduct, but close enough. Yes, Your Honor. The Goldstein problem is one of the is one of many problems with the court's commentary. But as Judge Orfinger was pointing out earlier, the real issue is that these are unsubstantiated matters that are going into the sentencing determination, the court's sentencing process. I see that I'm running short on time, and there are just a couple things I need to point out very quickly. First of all, regarding the Strickland prejudice prong, the court in Johnson made it very clear that the the court's express consideration of an improper factor before imposing the maximum sentence there establishes that prong. So reading from Johnson, although the minimum sentence was 25 years, the trial judge imposed a life sentence after emphasizing Johnson's refusal to admit guilt and assertions of innocence both at trial and sentencing. These improper considerations by the trial judge undermine our confidence in the outcome of the sentencing proceeding. So the prejudice prong of Strickland is unambiguously established here. Second of all, counsel also made the point that we don't know that had counsel objected, the court would have just offered other proper reasons for the sentence. The next sentence in Johnson dismisses that as well, where it says that the dissent speculates that had counsel objected, the trial judge would have simply withdrawn his reliance on these improper factors and reimposed sentence. And it goes on to say that the fact that a court subsequently offers additional reasons to justify a sentence that was originally based on improper factors does not necessarily cure the error. So
All right,
here,
so although you probably talk so fast, you got an extra minute there, we're going to have to cut you off.
yes, Your Honor, I understand. Thank you all for your time.
Thank you both. We'll be in recess until our 10 o'clock hearing. Thanks.
Thank you.
Thank you.